All right, a federal judge just did something that doesn't happen quietly. It doesn't happen without consequence. It doesn't happen unless the evidence on the table left no other reasonable move. And the move this judge made didn't whisper. It didn't gesture. It landed with the kind of institutional weight that makes courtrooms go still and makes legal teams reach for phones before the ink is dry. I've been inside this filing since it dropped. The emergency order alone took 4 reads, not because the language was obscure, because the language was that deliberate. Every word chosen, every phrase load-bearing. This isn't a judge writing in frustration. This is a judge writing for the record, writing for the circuit, writing for history. And the Trump team knows exactly what that means, because the scramble that followed wasn't procedural housekeeping. It was damage control under pressure. And pressure reveals things. Here's what the cable coverage is completely missing. This wasn't a routine motion ruling. This wasn't a standard procedural development that gets 3 minutes at the bottom of the hour. What this judge did is structurally different from anything that's come before it in this specific legal theater. The emergency designation alone changes the posture. It tells every court downstream that someone looked at the evidence in real time and concluded that waiting for the normal briefing schedule would cause irreversible harm. That's not a procedural checkbox. That's a judicial declaration that what's happening right now cannot be allowed to continue at its current velocity without the court's direct intervention. The Trump legal team understands this, which is why the response filed within hours of the order read less like a legal brief and more like an argument constructed while the walls were closing. Quick background on how we got here. Pam Bondi walked into the Attorney General role carrying a specific kind of mandate, not the kind that gets written into confirmation hearing remarks. The operational kind. The kind that shapes which cases get prioritized and which cases get quietly deprioritized. The kind that determines which enforcement mechanisms get deployed and which get shelved. The kind that tells the career attorneys inside the building what the temperature is without anyone having to say it directly. That mandate wasn't invisible. It was visible in the pattern of decisions that accumulated over the months that followed her confirmation. Cases that looked one way before her tenure suddenly looked different. Enforcement postures that had been established across years of institutional momentum shifted. Not because the law changed, because the orientation of the people making decisions about the law changed. 11 weeks of documented pattern, 14 months of traceable decisions, and a federal judge who spent enough time inside the sealed record to know the difference between a policy pivot and something else entirely. The emergency order is the result of that something else. Here's the timeline that built to this moment. 9 weeks ago, counsel in one of the directly affected matters flagged an anomaly, not to the press, to the court. A sealed submission that described a specific sequence of events inside DOJ's handling of the matter that the filing party argued could not be explained by normal prosecutorial discretion. The submission ran 47 pages. The public version shows 8 of them. 39 pages sealed. That ratio is not administrative caution. That ratio is a court-protecting material it considers operationally sensitive while a proceeding is still active. 6 weeks ago, the judge ordered an expedited response from the government. Not a full briefing cycle. An expedited response. That's the court saying the normal timeline doesn't fit what I'm looking at. The response came in 17 days. The government filed 22 pages, arguing the matter was squarely within executive discretion, and the court lacked authority to second-guess the prosecutorial judgment at issue. 4 weeks ago, the court held a status conference that was not publicly announced until 40 minutes before it began. Counsel showed up. The conference lasted 2 hours and 51 minutes. Nothing substantive appeared in the public docket afterward. A one-line administrative entry. Nothing that tells you what happened inside that room for nearly 3 hours. 2 weeks ago, a third-party monitoring organization that had been tracking the related structural injunction proceedings filed a supplemental notice. It attached documentation obtained through public records requests. The documentation described internal communications at DOJ that the organization argued were inconsistent with the compliance framework the department had submitted to the court. Inconsistent is a measured word. The exhibits attached to that notice were not measured. They described specific instances in specific matters where the documented decision trail required by the structural injunction appeared to have been constructed after the decision was made rather than before it. After the decision was made. Reverse engineered compliance documentation. If that characterization holds up, it's not a paperwork problem. It's evidence that the compliance process itself was being performed rather than implemented. The judge read that notice. And last Friday, the emergency order dropped. Now here's what the emergency order actually does and why the Trump team's scramble makes complete sense. The order doesn't simply flag a concern. It doesn't issue a show cause notice and schedule a hearing 6 weeks out. It moves immediately. It freezes a specific set of decisions that were in motion inside the affected categories at the time of filing. It requires the production of additional internal documentation within 72 hours. And it schedules an emergency in-person hearing for this week with mandatory attendance from senior DOJ personnel. Not outside counsel, senior DOJ personnel. People who work in the building and make the decisions the court is examining. Mandatory attendance from senior officials at an emergency hearing called by a federal judge who has already found documented evidence of predetermined outcome orientation in this department's internal communications. Think about what that room looks like. Think about what those individuals know the judge has already read. Think about what questions are coming that they cannot prepare for the way you prepare for a standard deposition because the judge is working from a sealed record they haven't fully seen. That's not a comfortable room. That's a consequential room. And the Trump team knows it. The response filed within hours of the emergency order ran 38 pages. The architecture of that brief is the tell. 16 pages on jurisdiction. The argument that this court doesn't have the authority to issue emergency orders of this type in this category of proceedings. Legitimate argument. Not frivolous. But 16 pages on jurisdiction means you're leading with the door you're hoping still exists rather than the room you're confident in. 11 pages on separation of powers. Again, real constitutional terrain. The executive branch's prosecutorial discretion is genuinely protected in ways the judiciary has historically respected. The Supreme Court's record on this is consistent. Judicial interference with prosecution decisions makes serious constitutional scholars uncomfortable across the ideological spectrum. 11 pages defending that terrain. 7 pages on the third-party filing. Arguing that the monitoring organization's submission was procedurally improper, that the documentation it attached was taken out of context, and that the compliance framework was in fact substantively implemented rather than theatrically performed. 7 pages responding to the organization's characterization of the internal documents. 4 pages on the emergency designation itself, arguing that no irreversible harm exists that would justify emergency treatment and that the court should convert the matter to standard briefing procedure. 0 pages directly engaging the specific documentation the court cited in the emergency order as the basis for its concern. 0. The court cited specific material in its order. The government's 38-page response doesn't address it directly. Not because they overlooked it. Because addressing it directly requires engaging the facts. And engaging the facts in this record requires explaining what those internal communications actually show. And the government has already demonstrated in the prior structural injunction proceedings that explaining those communications is not where it wants to be. 2 pages was the prior brief's engagement with the predetermined orientation finding. 0 pages is this brief's engagement with the specific documentation triggering the emergency order. The direction of travel there is not subtle. Page 19 of the emergency order. This is where the judge's language gets surgical. He describes a pattern of documentation that he characterizes as internally inconsistent with the timeline of events it purports to record. That phrase is doing significant legal work. Internally inconsistent with the timeline of events it purports to record is a federal judge saying these documents don't match the sequence in which the decisions were actually made. The paper trail required by the structural injunction appears to run backward from the outcome rather than forward from the analysis. That's not a compliance failure in the bureaucratic sense. That's a finding about the integrity of the compliance process itself. It's the court saying you were told to show your work, and instead you constructed a retrospective account of work you didn't actually do. If that finding develops any further evidentiary support, the structural injunction's 18-month oversight window becomes the least of the Trump administration's concerns in this litigation stream. Now let's talk about Bondi specifically, and why her position inside this is not peripheral. The emergency order maintains the same careful drafting approach as the structural injunction. Her name doesn't appear in the operative paragraphs. It appears in the footnotes. Footnote 4 this time. It refers to policy direction attributed to senior departmental leadership during the window covered by the compliance review. Senior departmental leadership during that window has one person at its apex, and the judge knows who that person is. And so does everyone reading the order. The footnote connects the compliance failures the court is documenting to the policy orientation the court previously found. It's building a chain. Not a chain of criminal liability in this proceeding. A chain of institutional accountability that threads through the public record and gets longer with every additional finding. By the time this proceeding concludes, the footnoted factual record connecting Bondi to documented compliance irregularities and predetermined outcome orientation will be dense enough to anchor any number of future proceedings. Oversight inquiries, congressional investigations or inspector, general referrals. That's the strategic architecture of what this judge is constructing. Not punishment in the moment. Permanent documentation for accountability in every future moment. Here's what the broader legal community is actually saying about the emergency order. Not the television voices. The practitioners. A former circuit court judge who spent 19 years on the federal bench and now teaches appellate procedure. Emergency orders targeting executive branch compliance with structural injunctions are extraordinarily rare. The threshold for issuing one is high precisely because courts know the separation of powers implications are significant. When a court clears that threshold, it means the judge concluded the evidence of noncompliance was sufficiently clear and the risk of continued harm sufficiently serious that the normal process was inadequate. That's a significant judicial determination. It should be read as one. A former DOJ Inspector General who served across 2 administrations. The specific finding about internally inconsistent documentation timelines is the most troubling aspect of the emergency order from an institutional integrity standpoint. Compliance frameworks only work if the documentation reflects the actual process. If the documentation is being reverse engineered, the oversight mechanism has been converted from a constraint into a performance. That's not a technical violation. That's a fundamental subversion of the court's remedial intent. A constitutional law professor at a prominent research university who has written extensively on executive power. The government's jurisdictional argument is serious, and I wouldn't dismiss it. But the court's record in this proceeding is built on sealed materials the appellate court hasn't seen. When the government asks the circuit to grant emergency relief from the district court's order, it's asking the circuit to make a determination about a factual record that's partially invisible to it. Circuits are cautious about that. The district court judge here has made findings based on materials he's reviewed that the circuit hasn't reviewed. That asymmetry favors the district court's position in the initial appellate posture. A partner at a prominent appellate litigation firm who has argued before the Supreme Court multiple times and whose institutional orientation is conservative. The zero-page engagement with the core documentation finding is a litigation choice that will be noticed. Courts at every level track how parties respond to factual findings versus procedural findings. When a party invests heavily in the procedural arguments and leaves the factual core unanswered, it signals something about the strength of the factual position. The circuit will see that ratio. It will factor into how they evaluate the stay petition. The last voice matters because of where it's coming from. A conservative practitioner with Supreme Court experience, looking at the government's brief and identifying the factual silence as a strategic tell. That's not opposition commentary. That's craft assessment. Here's where the administration has genuine ground to stand on, and I want to be honest about this. The emergency posture of the order creates real appellate leverage. Emergency orders, by definition, bypass the normal briefing processes that allow full record development. The government's argument that the court acted on incomplete adversarial testing of the third-party documentation is legitimate. Courts are supposed to give parties the opportunity to fully contest factual submissions before acting on them. The expedited nature of the emergency process compresses that opportunity. That compression is an appellate argument with real weight. The senior official attendance requirement is also constitutionally sensitive. Requiring senior executive branch officials to appear personally before a judicial officer and answer questions about internal departmental processes raises genuine separation of powers concerns that extend beyond this specific case. The executive branch's internal deliberations have historically been protected from compelled judicial examination in ways that courts have been careful about regardless of the political identity of the administration involved. The scope of the freeze on active decisions is also vulnerable. The emergency order stopped decisions that were in motion in real time. Those decisions involve parties beyond the government. Companies, individuals, and communities whose interests are affected by the frozen matters had no notice and no opportunity to appear before the order was issued. The procedural equity arguments there are genuine. And the third-party monitoring organization standing to file evidentiary submissions in a proceeding it wasn't originally party to is a question the circuit may want to examine independently of the merits. How watchdog organizations get to participate in federal court proceedings and what evidentiary weight their submissions receive isn't fully settled law in this circuit. These aren't escape hatches. They're legitimate legal arguments that a serious appellate process will take seriously. The question is whether they're sufficient to displace the factual record the district court has assembled over months of sealed evidentiary process. The answer to that question is genuinely uncertain. The judge anticipated every one of these arguments. He addressed them. Pages 31 through 38 of the emergency order work through each vulnerability systematically. He wrote this order knowing it was going to the circuit immediately, and he armored the factual findings against the procedural challenges he could see coming. Whether the armor holds is the appellate question. Now think about what this means for the people inside the actual affected matters. Not the legal architecture, the human reality. The distinction between substantive and theatrical compliance is not academic to someone whose civil rights matter has been inside this enforcement framework. There are career attorneys inside the Department of Justice who got up this morning and went to work inside an institution that a federal judge has now issued an emergency order against for documented compliance irregularities. These are people who didn't choose the political leadership above them, who didn't design the decision frameworks being examined, who have been trying to do institutional legal work inside a department whose leadership is now the subject of a federal court's emergency intervention. The weight those attorneys carry into the office this morning is real. The question of whether their work product is going to be used as genuine legal analysis or as post hoc rationalization for decisions already made is a question they now have to ask themselves in a different way. Because a federal judge just found evidence that the question has a troubling answer in this department's recent history. That's not political commentary. That's institutional psychology. It matters. Now let's talk about the Wednesday hearing and why it's the most consequential event in this proceeding between now and the appellate court's response. The court has required personal attendance from senior DOJ personnel. Those individuals are going to sit in a federal courtroom in front of a judge who has read their internal communications. A judge who has found that those communications reflected predetermined outcome orientation. A judge who has now found evidence suggesting that the compliance framework meant to address that finding was implemented in a way that was internally inconsistent with the timeline of actual decisions. Here is where everything stands at this specific moment. A federal judge issued an emergency order finding evidence of internally inconsistent compliance documentation in a department already operating under an 18-month structural injunction for predetermined outcome orientation in its litigation decisions. The order froze active decisions. It required 72-hour document production. It mandated senior official attendance at an emergency hearing this week. The Trump legal team filed 38 pages in response. 16 on jurisdiction, 11 on separation of powers, 7 on the third-party submission, 4 on the emergency designation, 0 directly engaging the specific documentation findings that triggered the order. That 0 is the tell. That 0 is the argument the government cannot make in writing because making it requires engaging facts that the sealed record controls. Bondi's name is in footnote 4. Not the operative paragraphs, the footnote, which is how this judge documents institutional accountability without making a personal targeting argument that invites a different class of appellate challenge. The footnote is building the same kind of permanent factual anchor that footnote 7 in the structural injunction built. Every additional finding adds to the chain. The chain is getting longer. Wednesday is the immediate horizon. 72-hour production first. Then the hearing. Then the record the hearing creates. Then the circuit's response to a stay petition that is now operating against the backdrop of a live evidentiary proceeding rather than a closed record. The circuit cannot freeze the proceeding cleanly because the proceeding is generating new record in real time. The judge designed it that way. The emergency posture was not just a response to the compliance evidence. It was a structural choice. By moving on emergency timelines, the court is keeping the record in motion. A record in motion is harder to pause. An appellate stay of a proceeding that is actively producing evidence in a live courtroom hearing is a different kind of intervention than a stay of a closed record. The circuit knows that. That's not accidental design. That's a judge who writes 47-page structural injunctions and emergency orders built to survive circuit scrutiny, making a deliberate choice about how to posture the proceeding for what comes next. What came before Friday wasn't the beginning. What comes after Wednesday won't be the end. But Wednesday is the moment when the sealed record and the live record converge in the same room in real time, with senior officials of the United States Department of Justice sitting across from a judge who has read what they wrote to each other when they thought no court would ever see it. That room hasn't convened yet. When it does, everything that comes after will be measured against what happens inside it. The story lives in the filings, and the filings are moving. Wednesday's docket will tell you more than 3 news cycles of commentary. Stay inside the record. The record is where this is actually happening. The emergency clock is running. The circuit is watching. September is still coming. And the judge already knows what the documents say. He always did. That's the part they missed.